Distinguished participants, ladies and gentlemen, thank you all for taking the time to join this discussion on a very important topic, namely broadening the recognition of the jurisdiction of the International Court of Justice. As we mark this year the 75th anniversary of the inaugural sitting of the ICJ and contemplate the outstanding contribution of the Court to the development of international law and its judicial application in support of maintaining peace and security worldwide, it is even more appropriate to look into ways of encouraging a wider use of the Court's jurisdiction. Therefore, it is a great honor for me to host today's event, which follows the virtual high-level roundtable on the same topic organized by Romania on June 24 this year, and which I also had the pleasure to host. As we announced on that occasion, we intended to launch a campaign aimed at encouraging states to accept the ICJ's jurisdiction, building upon previous initiatives in this area. Today, we are starting this campaign. Beyond my position of current Minister of Foreign Affairs of Romania, I'm also a professor of international law and member of the International Law Commission, as well as a former pleading agent before the International Court of Justice. That is why, for me, it is more than natural to attach great importance to the peaceful settlement of disputes, not only from a theoretical, but also from practical perspectives. The respect for this fundamental principle also lies at the heart of Romania's foreign policy, together with the respect for the whole body of international law and the promotion of the international rule of law. This should be an integral part of the foreign policy of each and every state in the world. I firmly believe that one concrete way through which we can accomplish this is strengthening ICJ. Expanding the court's compulsory jurisdiction through various options may consolidate the normalcy of submitting a legal dispute to the court, even if, or especially when it is a matter of importance to the security or the international profile of the respective country. I have advanced the idea of launching a campaign for intensifying the outreach demarches by states supportive of the ICJ in favor of an enhanced use of the World Court during a visit I made 1 year ago at The Hague on November 9, 2020. Then I have exchanged views with the President and the Registrar of the Court regarding the potential means through which us, the states, could contribute to increasing the essential role that the Court has for the international community. The ICJ high officials welcomed the proposal I have advanced at that point, which is part of the strong support of Romania for the ICJ. We initiated this demarche with a group of supporting states composed of Japan, Liechtenstein, Mexico, the Netherlands, New Zealand, Norway, Poland, Spain, and Switzerland, whose contribution and involvement in this exercise is highly appreciated. Together, we have elaborated the declaration on promoting the jurisdiction of the ICJ, which will lie at the heart of the global campaign dedicated to this goal. Immediately after today's event, the text of the declaration will be circulated to all UN member states and opened for endorsement by any interested state through a note verbal submitted to the Permanent Mission of Romania to the United Nations in New York, acting as depository for this initiative on behalf of the core group. Updated information on the endorsing states will be posted on the websites of our Permanent Mission in New York and the Romanian Ministry of Foreign Affairs. Insofar as the structure and the content of the declaration are concerned, this document refers to the ICJ's important role in promoting the rule of law globally and inventories the main reasons for accepting the court jurisdiction, specifically its competence over any legal dispute among states, its vast expertise in dispute settlement, its efficiency and affordability as a dispute settlement mechanism, its anchoring in state consent as the basis for its contentious jurisdiction, and its contribution to the realization of the principles and purposes of the United Nations, such as the maintenance of international peace and security. Not least, it encourages states to have recourse to the ICJ and confer jurisdiction on the court by any of the means envisaged in its statute. In addition, the declaration states the added value of declarations recognizing the jurisdiction of the court as compulsory and the benefits of the compromissory clauses in treaties on the rationale that accepting on a predictable basis the ICJ's jurisdiction builds expectations of stability and consistency in international relations and thus serves the cause of international peace. At the same time, the declaration encourages states, where appropriate, to consider withdrawing the reservations made to the specific dispute settlement provisions in international treaties conferring jurisdiction on the court, and to include compromissory clauses in new bilateral and multilateral treaties. On a general note, the declaration invites states to exercise great care when drafting titles of jurisdiction in order to avoid disputes over the jurisdiction of the court. Moreover, the declaration recognizes the merit of and draws on previous initiatives at the international and regional levels, such as the Handbook on Accepting the Jurisdiction of the International Court of Justice, developed by Switzerland, the Netherlands, the United Kingdom, Lithuania, Japan, and Botswana. These demarches should be seen as mutually reinforcing, given that the purpose of this initiative is to re-energize efforts dedicated to expanding the access to the ICJ's jurisdiction by putting forth a platform of political commitment to work systemically towards this goal. By endorsing this declaration, states will reaffirm their support for international law in conducting their foreign affairs and their readiness to advance legal arguments in defense of their positions before the leading international court as a means of translating into practice the principle of peaceful settlement of disputes enshrined in the UN Charter. We see the growing docket of the court covering a wide array of topics and involving states from various geographical areas of the world, together with the references to the jurisdiction of the court in numerous conventions of universal application, as indicative of the state's rising confidence in its highly quality judicial work and in its ability to prompt solutions that bring disputes to a peaceful resolution. Therefore, we hope to gather substantial support for this declaration. The more we rally around this initiative, the more we can convince states to bring their disputes to the court. A high number of endorsements could serve for other states as a springboard for action at the domestic level towards accepting the ICJ's jurisdiction. In terms of follow-up measures, Romania envisages undertaking outreach activities by the core group states within their respective regional groups and in their bilateral contacts. We also intend organizing dedicated events or using related conferences or opportunities, like the presentation of the annual report of the ICJ to the UN General Assembly, to disseminate information about this declaration and continue to persuade all states to join in. While countries exert their free will in choosing the most appropriate means of peaceful settlement of disputes in each context, I cannot underscore enough the importance of judicial adjudication mechanisms, and in particular the authoritative value of ICJ's judgments as reliable instruments bringing durable solutions based on law for any disputes between states. The court is the essential element of the international justice system, while its jurisprudence provides guidance to states in the interpretation of international norms and hence fosters dialogue and cooperation among governments. To conclude, let me reiterate the invitation included in the declaration to all interested states to join us in the efforts to further promote the ideal of universal acceptance of the jurisdiction of the court. I thank you, and I'm looking forward to the enriching discussions on this topical initiative. And let me now start our conversation. Before opening the floor to the distinguished participants, I would like to mention that we have received a few kind requests for taking the floor earlier due to conflicting schedules. I count on your understanding to accommodate them. The first such request comes from distinguished representatives of the Kingdom of the Netherlands to take the floor at the beginning of the meeting, as her agenda does not allow otherwise. Therefore, with your indulgence, if you agree, I will start by giving the floor to Her Excellency Mrs. Jokka Brandt, Ambassador Extraordinary and Plenipotentiary, Permanent Representative of the Kingdom of the Netherlands to the United Nations. Ambassador, you have the floor.
Thank you very much, Minister Rescu, for your commitment and for your inspiring presentation just now, and for also being kind enough to give me the floor early. I wouldn't want to have missed being present here, because the Kingdom of the Netherlands is honored to co-host, co-organize this event together with other core group states. And we are proud to be the host country of the International Court of Justice and take every opportunity to support the court and stress the importance of its work. The International Court of Justice, as you just said, is the world court. For it to function well, all states should accept the jurisdiction of the court with as few reservations as possible, because It is not a nice to have option available when it suits you. You have to commit to it, even when it's not so convenient. That is why the Netherlands has accepted the jurisdiction of the ICJ with only one reservation, and that is for disputes that date back more than 100 years. The launch of the declaration comes at a very timely moment. The declaration underlines the importance of the jurisdiction of the court, and it explains why the court should have a broad mandate, both in terms of substance and in terms of subjects. Because only with such a broad mandate can it truly function as the primary judicial organ of the world community. The Netherlands therefore fully supports the declaration. Let me therefore also take this opportunity to encourage all member states that have not yet done so to accept the compulsory jurisdiction of the court, in this way demonstrating their commitment. We believe that a rule-based international order will benefit all. The International Court of Justice has an essential role in this. It deserves and indeed has our full support. I thank you, Mr. Minister.
Well, thank you so much, Ambassador, and let me join you in the appeal for all states to join our declaration, and also for, if possible, accepting the compulsory jurisdiction through declarations made under the statute, as we have done in 2015, and I'm proud to say that Romania was the 72nd state to accept the compulsory jurisdiction of the court. It is my pleasure now to give the floor to Mrs. Victoria Hallam, Chief International Legal Advisor and Divisional Manager in the New Zealand Ministry of Foreign Affairs and Trade. You have the floor.
Thank you very much, Minister Rescu. We are very pleased to be a member of the core group for this initiative. Aotearoa New Zealand is a strong supporter of the International Court of Justice as the primary judicial organ of the United Nations. The willingness of states to submit their disputes to binding dispute settlement is a key feature of an international system based on the rule of law that promotes peace and security for all states. We welcome this opportunity to promote the jurisdiction of the International Court of Justice, and we strongly endorse the declaration. I thought I would address my remarks to the issue of compulsory jurisdiction, even though the declaration covers a broader range of issues, as New Zealand is a really strong supporter of the compulsory jurisdiction. We had already accepted the compulsory jurisdiction of the court's predecessor, the Permanent Court of International Justice, back in 1929. When the new court was created at the San Francisco Conference in 1945, we were represented by our Chief Justice of the time, Sir Michael Myers, and we advocated strongly for the compulsory jurisdiction of the court to be generally applicable. Now, while this did not succeed for the International Court of Justice, subsequent collective efforts in the UN Convention on the Law of the Sea and the World Trade Organization did achieve that aim. As the declaration states, the court's role in maintaining international peace and security can be enhanced by extending access to its contentious jurisdiction. We consider that all states benefit from the expansion of the court's contentious jurisdiction, as this promotes both the peaceful settlement of disputes as well as the court's contribution to the development and interpretation of international law through its jurisprudence. New Zealand considers that it has benefited greatly from the court's judgments in both contentious and advisory cases. New Zealand has been an active participant in 3 contentious cases before the ICJ, all on issues of great interest to the New Zealand public. Our most recent engagement was in the case on whaling in the Antarctic, in which New Zealand intervened. New Zealand has also initiated 2 contentious cases to respond to nuclear testing in the Pacific region, the 1973 and 1995 nuclear test cases. I myself was fortunate to be junior counsel in the 1995 case. The first case, which focused on atmospheric nuclear tests, led to provisional measures being ordered. The court did not, however, rule on the merits as by that time France had announced that it would cease its atmospheric nuclear tests. The court held that the New Zealand objective in bringing the case had in effect been accomplished and so did not need to further rule on the matter. And interestingly, in reaching this conclusion, the court determined that France's unilateral declaration was of binding effect. Then in 1995, New Zealand sought to reopen the earlier case in response to underground nuclear testing. That case was not successful, although France ceased nuclear testing permanently shortly afterwards. As former New Zealand legal advisor and current International Law Commission candidate, Penelope Ridings has written in a forthcoming publication on dispute resolution, there is strategic value in third-party dispute settlement that goes beyond the particular outcomes of a case. Dr. Ridings argues that even when the outcome of a case is not the one sought, the state initiating the case still benefits, as the dispute is resolved and the country's international relations are returned to a more secure footing as a result. She also observes that binding international dispute resolution can satisfy important domestic stakeholders that all avenues have been pursued, and thereby it can encourage acceptance of the result back at home. New Zealand has a deep appreciation for the court's jurisprudence in developing and applying the principles of international law, and notes that states also contribute to this through their participation and argumentation in cases. In New Zealand's situation, this has included contributing to the law on binding unilateral declarations, as I just mentioned earlier, the legal obligation not to cause transboundary harm, and giving more substance to the duty of cooperation in the management of shared resources. So, in conclusion, New Zealand's experience with the International Court of Justice leads us to encourage other states to join the declaration and to confer jurisdiction on the court through the various methods outlined in the declaration. Thank you very much.
Thank you so much for your statement, and I now have the pleasure to invite Mr. Christian Erwell, Director General of the Legal Department of the Ministry of Foreign Affairs of the Kingdom of Norway, to take the floor. I understand we have a small technical problem. I would like now to give the floor to Mrs. Corinne Ciceron-Bühler, Director of the Directorate for International Law and Legal Advisor of the Federal Department of Foreign Affairs of Switzerland, to take the floor.
Mr. Minister, Excellencies, first and foremost, I wish to thank Romania for its initiative. Switzerland is honored to be part of the core group that drafted the declaration on promoting the jurisdiction of the International Court of Justice. We welcome such opportunity to support the court and its crucial role in the international community. Switzerland has a long history in supporting the court and its work. The Swiss declaration recognizing the court's jurisdiction was made in 1948, 54 years before Switzerland joined the UN. This is a testimony to the trust Switzerland places in effective, peaceful settlement mechanism in general and in the ICJ in particular. At the time, Switzerland opted for a declaration that did not include any reservation. This declaration has remained unchanged since. Such lack of reservation remains unusual, and Switzerland hopes that the present initiative will change this state of facts. Switzerland has also been on a few occasions involved in ICJ proceedings, including as recently as 2009 as a respondent. However, its commitment has remained unwavering. Switzerland is strongly of the opinion that a broad declaration generally recognizing the jurisdiction of the ICJ entails much more opportunities than potential risks. Excellencies, in Switzerland's view, the present declaration offers an important opportunity to further promote an institution that is crucial to international peace and security. Many interstate conflicts grew for years before erupting to the detriment of all. Recourse to an independent third party, such as the ICJ, might present political challenges, of course, but it also diffuses certain tensions very effectively. We therefore hope that the declaration will spark a renewed interest in the ICJ's key role in peaceful dispute settlement. Switzerland strongly believes that signing this declaration benefits not only to each signatory, but also to the wider international community. I therefore invite all UN members to sign this declaration promoting the jurisdiction of the ICJ. The sum of the declarations will be greater than the parts. I thank you very much.
Thank you so much, Madam Director, for your statement. And I have now the pleasure to invite His Excellency Mr. Augustin Santos Maraver, Ambassador Extraordinary and Plenipotentiary, Permanent Representative of Spain to the United Nations. Sir, you have the floor.
Thank you very much, Your Excellency, Minister Aurescu, dear colleagues. Allow me to thank Romania once again, as I did on the roundtable of 24th of June, for bringing to the attention of the member states the tools that we, states, can use to integrate and bring further the contentious jurisdiction of the International Court of Justice. Something, I think, that runs in parallel to the strengthening of the notion of the rule of law in international relations and to the strengthening of an international order based in international law. Today, we are using the opportunity of the recent plenary debate on the ICJ annual report before the General Assembly to launch a declaration among a group of states on our relationship to the ICJ. A declaration that makes a comprehensive description of the sources of jurisdiction of the International Court of Justice that are in the hands of states and calls upon them, as this declaration states in the last sentence, to engage in a systematic manner in efforts to further promote the ideal of universal acceptance of the jurisdiction of the court. Spain is pleased to include its signature to this invitation. In this respect, I will refer to what Spain considers the quintessential way to express confidence with the ICJ and its role between the UN system. Declarations of voluntary acceptance of the contentious jurisdiction of the court. To embody this expression of trust and confidence, this declaration should be as abstract and simple as possible, without expressions of reservations or restrictions as to the subject matter or beyond the position of validity in time and in relation to the formulation of other declarations by other states. Spain had this in mind when it issued its declaration of acceptance of the compulsory jurisdiction of the court on 29th October 1990. After listening to the debate in the General Assembly Hall on the ICJ last Thursday, it seems obvious that we are currently experiencing a sweet spot in the degree of confidence of states in the court. This is both in terms of the number of states currently acting before it, and in terms of the number of questions of public international law currently before it. However, the number of voluntary declarations of acceptance of the court's contentious jurisdiction does not seem to be experiencing a significant correlation to the theoretically sweet spot of confidence that the court enjoys today among states. Still, only 74 states have, as today, issued declarations of acceptance of the compulsory jurisdiction of the International Court of Justice, which leaves much room for improvement. The issuance of state declarations accepting the contentious jurisdiction of the International Court of Justice is a prerogative in the hands of states. But at the same time, it's a powerful means of expressing trust in the jurisdictional function of the principal judicial organ of our organization. And it is also a contribution to giving substance to its role. Spain's hope is, as I also said on the events last June, that this initiative will result in a spike of declarations of acceptance of the court's jurisdiction, bringing us closer to the degree of confidence that the international community owes to the principal judicial organ of the United Nations. The success of this initiative will be a sign that the world is moving in the right direction, and you can count on Spain to support this systemic effort in trying to align the current confidence the court enjoys with the number of declarations of acceptance of its compulsory jurisdiction deposited with the Secretary General. Thank you very much, dear colleagues. Your Excellency, Minister Aurescu, thank you for organizing this meeting.
Thank you so much, Ambassador, for your statement and for your support. And I now have the pleasure to invite Mr. Krzysztof Szczerski, Ambassador Extraordinary and Plenipotentiary, Permanent Representative of the Republic of Poland to the United Nations. Krzysztof, it's good to see you again. Please, you have the floor.
Thank you very much, Bogdan. Excellency Minister Aurescu and Excellency distinguished colleagues, let me begin by saying it's a great honor for me to join the group of promoters of the idea of widest possible use by states of the ICJ services in resolving the interstate disputes. And let me also thank and congratulate my dear colleague and friend Bogdan Aurescu, Romanian Minister of Foreign Affairs, for putting forward and implementing this initiative. The initiative that, in fact, is to support the International Court of Justice, as the mandate and the mission of the court cannot be entirely fulfilled without the support of all the UN member states. But to win the support of all, the commitment of some is needed first. And this is the goal of this initiative. Hence, our declaration and campaign, which we launched today, is a kind of declaration of goodwill and faith of us as the core group. As we heard, so far, 74 states expressed their consent to the compulsory jurisdiction of the ICJ. Between those countries, no special arrangement to subject any particular dispute to the jurisdiction of the court is required. Thus, acceptance by a state of the compulsory jurisdiction of the ICJ in legal disputes is a significant sign for the international community. It represents the readiness of a state to solve its international disputes on the basis of international law. Poland recognized the compulsory jurisdiction of the ICJ just after the political transformation in 1990, and again in 1996, seeing it as a manifestation of the will to belong to the community of rule-based nations. We believe that all states should consider making their declarations at a time and in a form that will be the most appropriate for them. It is worth reminding that states, when formulating their consent, have considerable autonomy in choosing appropriate formulation and limitations. Thus, we encourage all states to use this procedure, and we express our appreciation to those countries that have done so recently. As regards to the inclusion of the compromissory clauses providing for the jurisdiction of the ICJ in the national agreements, we fully support this idea, in particular in the context of multilateral treaties. We therefore urge all states not to make use of the possibility to submit a reservation to the compromissory clauses in the multilateral treaties, and we encourage to consider withdrawing already submitted reservation in this regard. In closing, I would like to quote the last paragraph of our declaration. We invite all interested states to engage in a systematic manner in efforts to further promote the ideal of universal acceptance of the jurisdiction of the court. We invite all to join our initiative, sign the declaration, and implement its provision, and I thank you very much.
Thank you so much, Ambassador dear Krzysztof, for your statement and for Poland's support. And I have now the pleasure to invite His Excellency Mr. Kimihiro Ishikane, Ambassador Extraordinary and Plenipotentiary, Permanent Representative of Japan to the United Nations. Sir, you have the floor.
Thank you, Mr. Minister. I'd like to begin by thanking the government of Romania for its initiative on the declaration on promoting the compulsory jurisdiction of the ICJ and for organizing today's launch event. As a member of the core group, Japan is pleased to see the declaration officially presented with support from many member states. Japan became a state party to the Statute of the ICJ in 1954, 2 years before it joined the United Nations and accepted compulsory jurisdiction of the court in And this is a testament to our confidence in the work of the court and to our long-standing commitment to promoting and strengthening the rule of the international community. Promoting the rule of law has long been one of the key pillars of Japan's foreign policy. But today, to a great concern, the rule of law faces growing challenges around the world. The rule of law must be strengthened in order to facilitate peaceful resolution of disputes in an equitable and predictable manner. Being a maritime nation, the rule of law in the maritime field is particularly important for Japan. We have consistently emphasized that states should make their claims and clarify them based on international law with a view to settling disputes by peaceful means. Japan fully supports General Assembly Resolution 75/141, which called on, quote, states that have not yet done so to consider accepting the jurisdiction of the International Court of Justice in accordance with the Statute, unquote. To date, 74 states have accepted the court's compulsory jurisdiction. In order to upgrade the rule-based international order, we are hoping that more member states, including those from the Asian Pacific Group, accept the court jurisdiction. With our other members of the core group and other states parties joining the declaration, Japan will continue to promote the acceptance of the court jurisdiction and support the fair and impartial work of the court. I thank you.
I thank you so much, Ambassador, for your statement and for Japan's support. And I have now the pleasure to invite His Excellency Mr. Christian Venavesser, Ambassador Extraordinary and Plenipotentiary of the Principality of Liechtenstein, Permanent Representative to the United Nations. Sir, you have the floor.
Good morning, Minister. I hope you can hear me. We're having a bit of technical difficulties here. Thank you so much for your personal leadership on this very important initiative, and thank you to your country, Romania, for bringing us together. It's a big honor and pleasure for us to be a part of the core group of this very important initiative. Liechtenstein is a very long-standing supporter of the work of the International Court of Justice. We have engaged actively with the court both on contentious cases and have been very favorable of a very strong role of the court with respect to advisory opinions. This is an expression of our strong commitment to the rule of law at the international level, on which we are also coordinating a General Assembly resolution together with our colleagues from Mexico on an annual basis. And we do believe that it has never been more important for the international community to have a mechanism in place that is in charge both of peaceful settlements of disputes and of giving us advice with respect to questions of international law. We do believe that the compulsory jurisdiction of the International Court of Justice, in accordance with Article 36(2) of the Statute of the ICJ, is a tool that should be utilized more, and we find the number of states that have made the relevant declarations disappointing, given the very high level of acceptance that the court's decisions do enjoy and the high standing that the International Court of Justice does benefit from overall. So, as indicated last week when we had the General Assembly debate on the annual report of the International Court of Justice, we are a strong supporter of this initiative, whose success, of course, will also be measured by the number of states that will be joining under the compulsory jurisdiction regime subsequently. You have talked about the activities that you have envisaged in this respect. We will be participating in them, and we also encourage those who are supportive of this initiative to take up this issue bilaterally with our colleagues who have yet to make these declarations, including in the context of candidatures they put forward for international justice positions. Again, many thanks to you, Foreign Minister, for your leadership on this, and it's a pleasure to be here.
Thank you so much, Ambassador, for your insightful words and for your support. and for your constant implication in favor of international rule of law. I would like now to try again to invite Director General Erwell from the Foreign Ministry of Norway, if you can speak to us.
Thank you very much, Your Excellency, for your patience. Can you hear me now?
Yes, we can hear you and see you. Thank you.
Excellent, very good. And my apologies for all the technical trouble here in Oslo today. But many thanks for your patience, and thank you very much, Your Excellency, for giving me the floor. And good morning to all your colleagues in New York. Allow me at the outset to thank Romania for this important and timely initiative. Norway is glad to be a member of the core group for the Declaration on the Promotion of the Jurisdiction of the ICJ. Norway attaches great importance to the International Court of Justice, the principal judicial organ of the United Nations. In a world with increasing tensions, the commitment to orderly settlement of disputes is more important than ever before. In the long run, a world where might goes before right benefits nobody, not even the mightiest of nations. We consider the ICJ a cornerstone of a rules-based international order, and hence the promotion of the court has been a priority for my country over the years. This was also very much the case of my predecessor, Ambassador Mr. Rolf Einar Fife, Norway and the Nordic states candidate for the ILC elections next week. I hope, Minister Aurescu, that the two of you will soon become colleagues in the National Law Commission. The ICJ occupies a special position, being the only international court of a universal character with general jurisdiction. The court plays a significant role in the promotion of the rule of law through its judicial activities and in contentious cases and advisory opinions. Throughout its period of operation, the subject matters in the cases referred to the court have varied greatly. As a general trend, I think the cases have been of growing factual and legal complexity. Consequently, the court is particularly well placed to provide clarification, guidance through its judicial activities on how to correctly understand the questions of international law. We believe the cohesion of international law is actively promoted by the court through its interpretation of treaties based on the principles and rules contained in the Vienna Convention on the Law of Treaties. The International Court of Justice plays a crucial role not only in the resolution of contentious cases and through its advisory role, but also in the clarification and development of international law. We welcome the court's contributions in various fields, including in the development of the modern law of the sea, and in particular, its role in consolidating and refining principles of maritime delimitation. In doing so, the court has provided invaluable guidance to states engaged in the negotiation of treaties on the limitation of continental shelf and economic zones. Norway also values the court's contribution to the peaceful settlement of international disputes, and we encourage states that have not already done so to recognize the compulsory jurisdiction of the court. The court can only fulfill its role if states accept its jurisdiction. Over the years, the court has proved highly capable of solving disputes through the application and interpretation of international law. Your Excellencies, ladies and gentlemen, I would like to conclude my intervention by again thanking Romania for its very valuable initiative to promote the acceptance of the court's jurisdiction. Let me also reiterate Norway's long-standing and unwavering support for the ICJ as a cornerstone of the international legal order. I look forward to a fruitful exchange of views during today's event and encourage member states to endorse the declaration. Thank you very much, Mr. Chairman.
Thank you so much, Director General, for your kind words and for your constant support, for Norway's constant support for the International Court of Justice, and for this initiative. I very much appreciated the virtual participation of the Norwegian Foreign Minister, my former colleague, Minister Soreide, to the event in June. And I wish every success to Ambassador Fife to the elections next week. I'm also looking forward to those elections. And I hope that I'll be able to continue as a member of the International Law Commission and as co-chair of the study group on sea level rise in relation to international law, which was a topic very much debated these days in the 6th Committee. I have now the pleasure to invite the representative of Mexico to address this event. So you have the floor.
Thank you very much, Minister Aurescu. It's an honor to be here with you, Excellencies. I first of all want to apologize on behalf of Ambassador Gomez Robledo. I'm coming in as his pinch hitter. He had to leave for an urgent issue now that we're in the Security Council and that we're having the presidency of the Security Council. Things come up and he deeply apologizes. He really wanted to be with you this morning. However, Minister, to be very honest, I don't have much to add in the sense that pretty much the messages that we wanted to convey have been already mentioned by our fellow panelists. And I think that also proves the fact that there's a reason why we're like-minded and we share this core group. I would also say that Mexico is a very proud member of this core group. Our region in particular is one that has always been a regular client, so to speak, of the court, which is only evidence of the trust that the region has, that the Latin American region has in the principal judicial organ of the United Nations. The widest number of pending cases in the court's docket at the moment it comes from the region of Latin America and the Caribbean. And Mexico in particular has always been a strong supporter of the court. We know not only have, of course, made a declaration recognizing the compulsory jurisdiction of the court, but our country herself has had recourse to the court as a choice of means for the peaceful settlement of disputes in the past. And this issue in particular, the importance of recognizing the jurisdiction of the court, is something that we also mentioned yesterday in the private meeting that the Security Council held with the President of the International Court of Justice. And this initiative is also something that we want to underscore in the upcoming signature event that we will have on the 16th of November in the Security Council, where the Council will have a conversation with the principal bodies of the UN, including the President of the ICJ, precisely to address how can efforts be strengthened for all principal organs to collaborate and to cooperate to advance the main objective of the maintenance of international peace and security. And the fact that less than half the member states of the United Nations have recognized the jurisdiction of the court is certainly one issue that we should be able to tackle and address head on. And for that, Minister, we are also very grateful to you for starting this initiative. We truly believe that this initiative was long overdue, and the 75th anniversary of the court is a good moment to issue this declaration and to rally member states around it. And we hope and expect many countries very soon to join. And as other panelists before me have mentioned, we also invite all member states to join this important initiative where sovereignty and consent are always respected. But what it does, it strengthens, as Ambassador Benavides also mentioned, the rule of law at the international level. And we are confident that this will be the case with this important initiative. Thank you very much, Minister, and we're very much looking forward to hearing the conversation that will follow to these presentations. Thank you very much.
I thank you so much for Mexico's commitment and for your kind words. And I would like to thank again all distinguished speakers for their insightful remarks and for their contribution and support to this initiative. It is now the time to open the floor to the audience. I think we have some 10 minutes for discussion. And I would like to invite anyone who is interested to take the floor. Ms. Fiona Webster, I think you want to address this event. Please, you have the floor. I think we can hear you, yes, please.
Australia wishes to thank the core group for their efforts in relation to this declaration. Our special thanks go to the Minister of Foreign Affairs. Sorry, can you hear me?
We can hear you with some difficulties, but please go ahead.
I'll just stop. That we've heard this morning strongly supporting the peaceful settlement of disputes between states, strengthening the affairs. The importance which Australia attaches is reflected in our long-standing acceptance of its compulsory jurisdiction. We believe that acceptance of the court's compulsory jurisdiction by the widest possible number of states enables the court to most effectively fulfil its functions. We encourage states which have not yet done so to consider depositing a declaration with the Secretary-General under Article 36, Paragraph 2 of the ICJ Statute. When drafting multilateral or bilateral treaties, states should also be open, where appropriate, to including clauses providing for the court's jurisdiction over disputes concerning the relevant treaty's interpretation or application. States' willingness to entrust the court with jurisdiction to resolve their disputes reflects their confidence in the court, the expertise and integrity of its members, and the fairness and rigour of its procedures. Intensified efforts to ensure that the court is representative and diverse will enrich the authority and the quality of the court's judgments and will encourage more states to turn to the court for the peaceful settlement of disputes. Australia welcomes this declaration and looks forward to giving it close consideration at the earliest opportunity. Thank you very much.
Well, I thank you so much for your statement, and thank you for Australia's support for the International Court of Justice and for the international rule of law. And I'm looking forward to see Australia joining this initiative. Is there anyone else who would like to take the floor from the audience? May I ask also the colleagues from the core group if they want to add anything to the debate? Well, if not, it means that everything is quite clear as far as our intention and determination and strong will to move forward with promoting this initiative. I do hope that this initiative will be successful, and I want to warmly thank again the representatives from the core group states for their involvement. I would also like to thank all participants to this event for their interest. We could, I think, easily identify a common denominator of today's interventions, which is the acknowledgement of the important contribution of the ICJ to the peaceful settlement of disputes and to the promotion of the rule of law globally, along with the recognition of the possibility to make better use of this important potential. And I think indeed, as it was stressed already, using the opportunity of the 75th anniversary of the work of the World Court, I think reaffirming our support for the ICJ's role is very timely. This declaration, I think, should mirror our renewed commitment to respect the international law, to use to the fullest the ICJ's mandate in support of peace and stability, and I think promoting a wider access to the jurisdiction of the court is very important in that respect. The court has constantly proved that it looks past the political circumstances of a case and decides in accordance with international law. In this context, we fully trust the court to continue to act as a promoter and guarantor of the supremacy of law in international relations. And we do hope that in the following weeks and months, many states from all over the world will join us in this demarche by endorsing the declaration. As I have announced at the beginning of my intervention, Romania, through our permanent mission in New York, will act on behalf of the core group as depositary of notes verbal, communicating states' support for this initiative, and we will inform everybody about the progress in joining to our initiative. This group of states will continue to invest in a systemic campaign for broader access to the court's jurisdiction, and again, we will invite the member states to rally around this cause. We express our gratitude to those delegations that have already taken this decision or are contemplating this possibility in the near future. And we remain, of course, ready to respond to any queries related to this initiative. Once again, on behalf of the government of Romania, on behalf of the Ministry of Foreign Affairs of Romania, on my own personal behalf as international law professor and member of the International Law Commission, I would like to thank you all for your support and for joining us in this, I think, very timely and important event. Thank you all for joining us.